Hello, everyone. Welcome. My name is Sarah. I'm with the Shelter Island Public Library, and I am here with Britt Burner from Burner Prudenti Law, and she's going to be chatting with us about probate, electronic wills, and all that good stuff. So I'm going to pass it over to Britt.
Thank you so much, Sarah, and thank you, Shelter Island Public Library. It's really great to be able to come to you all virtually, but I hope that you are all actually on Shelter Island enjoying yourself right now. Today's topic is interesting. We titled it Probate Then and Now. And really, what we were looking to get into the topic was talking about this new thing called e-wills or electronic wills. But before I get to all of that, I want to go back and I want to talk about the foundations, the basics, the then before I talk about the now. Um, Before I get into that, I just want to say my name is Britt Burner. I'm the managing partner of Burner Prudenti Law. We have offices from Manhattan all the way out to East Hampton. We have four offices. And we practice in the areas of trust and estates, elder law, and real estate transactions. And our firm has been around for over 30 years. It was founded by my mom, who is still my law partner, and we have 10 lawyers total. And so, yeah, we're just here really to educate you. Nothing here is meant to be legal advice. So please do take whatever information you learned today and go speak with your attorney about it or find an attorney to speak to about it, because none of this is legal advice and everything will change. The advice will change based on your individual facts and circumstances. So that is my first disclaimer. This is not legal advice. And my second disclaimer is this is very New York State based. Everything that we are going to talk about today is based on New York State law. So if you have a friend or a family member who lives in New Jersey or Connecticut or even as far away as California or Alaska, this might be similar in other states, but the nuance will matter. It will be something will be different. So please just remember this is all based on New York State law. So, getting into the probate then and now, probate then. So, what is probate? And I say all the time, probate needs a will and a will needs probate. What does that mean? So, if everybody, if I, or take me, if I were to sign a last will and testament and I wanted the terms of that document to be followed after my death, that paper is worth nothing more than being a bunch of scrap pages unless and until it goes through a court process called probate. The process of probate is defined as the process of bringing the will through the court where the court validates the will and appoints the executor. So if I have a document that I've signed and I've signed it properly with all the proper witnesses, etc., and it says that X person is my executor, that person is actually only nominated by me to be the executor, because until my will goes through this court process of probate and the court gives an official appointment to that individual, I don't have an executor. I will not have one until the court appoints one. Similar, if I have my asset is, my will says that my assets are to go to the Shelter Island Public Library, but I have beneficiary designations on all my accounts or a joint owner on my accounts that are to friends and family. Well, then the friends and family listed on the accounts will receive that money. It will not be the Shelter Island Public Library. The only thing that the library would receive in that example would be assets in my sole name without a beneficiary. So let's say, for example, I have a checking account that I keep, money in, money out every month, very small amount, $2,000, $3,000 at max, right? That's my checking, and that's in just my name. My house is also in just my name. But let's say I also have an IRA or a 403B, some kind of a tax deferred retirement account left over from my working years that I have designated a beneficiary on it to be my daughter. And I have a brokerage account, and that brokerage account is joint with my daughter. Well, then upon my death, my will is going to go through probate. And after probate, my will that says everything goes to the Shelter Island Public Library will give my house and that small bank account to the library. Because the IRA goes to my named beneficiary, my daughter, and my brokerage account that's joint with my daughter immediately becomes hers upon my death. So even though my will says everything goes to the Shelter Island Public Library, it can only cover those things that will pass through the probate of my will. Now, this isn't necessarily a bad thing, and we can use all that information to determine somebody's proper estate plan. This is why if somebody comes to see me and says, well, I want you to do a will that says everything goes to the library, I say, well, I need a list of what your assets are, because not only can I create the document that says that it goes to the library, but I also need to see what all of your accounts are to make sure that the accounts that you intend to go to the library are passing through the probate of your will. And so we have to look at beneficiary designations, joint ownership, and make sure that the whole plan works together. So what is probate process? We have heard a lot of people on TV, on the internet say everybody needs a trust and everybody should avoid probate. I don't necessarily think that's true. I think plenty of people, when with proper planning and understanding of what's going to happen, probate might be a perfectly wonderful way for their assets to pass upon their death. But there's certain situations in which probate might be a bigger problem. So, for example, in the process of probate, it requires notification to your legal next of kin that your will is going through probate. And those legal next of kin get a copy of your will and an ability to contest the will. So who are your next of kin, right? I will say that everybody has next of kin, whether you know them, whether you like them, you have them. They might be a child that you're disinheriting, or they might be a long lost fourth cousin that you didn't know existed. But everybody has them. So, for example, if someone is married and has children, their spouse and their children are considered what we call their distributees, their legal next of kin. And if you don't have a spouse, it's just your children. And if you don't have children, it's just your spouse. If you do have a spouse and or children, there's no reason to look any farther. So a lot of people get nervous. You know, I had people in last week, they're a married couple and they have a child and they said, well, what if our cousins come out of the woodworks? And I say, your cousins don't have standing as distributees because unless your spouse and your child dies, we're not getting to the next level. So it's very important to realize that your distributees are those at the first level of closeness to you. If you don't have a spouse or children, then we look to your parents. If you don't have living parents, then it would be the children of your parents. So any siblings, either half or full siblings. So you would have to share at least one parent, if not two, with them. If you don't have any living siblings, then we would look to the descendants of your siblings. That would be your nieces and nephews and down that bloodline. And then if we don't find anyone at those levels, then we would go up to the siblings of your parents. So the half or full siblings of your parents, and then go down those bloodlines and keep going out until we find someone. But again, once we find someone, we stop. Once we find a level of closeness, we don't have to keep going farther and farther out. And you could think of it as a family tree that goes like this, right? So this is first your descendants or your spouse, right? Then it's your parents and their descendants. Then it's their parents and their descendants, and it gets bigger and bigger the farther we have to go out. But we don't have to get to those higher up and farther out branches unless we can't find anyone at the closer levels. So that's the first reason we might avoid probate is if we don't know who our next of kin are, or if we're disinheriting them, because the court requires their notification. And if you cannot determine who those people are, or if you determine who they are, but they're being disinherited and you think they're going to cause a fight, well, then you'll likely want to avoid probate to avoid that notification. And that's where people start to talk about beneficiary designations, creating a trust, joint ownership, etc. People also like to avoid probate if you have property in multiple states. So say you own a property, you live in New York and New York State is your primary residence, but you own a condo in Florida. Well, in that case, your will would have to be probated both in New York and in Florida for that Florida property to pass. And they can't happen consecutively. They can't happen concurrently. Sorry, they have to happen consecutively. So it can be very costly and time consuming because you can't probate in Florida until your will is fully probated here in New York. And then an ancillary proceeding, it's called, is brought in Florida. And certainly, if you own property in more than two states, it could be even more. And so you want to make sure that you're being most efficient. So you want to think about where you own property. You also want to think about if you have minor or disabled beneficiaries that can't represent themselves. This could be a spouse who has a disability, it could be a child, a grandchild. If you have a minor or a disabled person as a beneficiary, the court will go through extra lengths to protect those individuals, which is great, but it can also be time consuming and costly to do so. And so a lot of people like to avoid probate in those circumstances. And then we like to avoid probate if somebody has a complicated estate, either because of the amount of money, meaning if they have a taxable estate that's over this year, New York State says everybody can leave behind $7.35 million. Anything below that, there's no tax. If you're above that, taxes are due within 9 months of date of death, and you would want your executor or the person in charge of your estate to be responsible for the assets and be able to access all the information needed in order to do the proper tax filings. And if probate's taking 4, 5, 6 months, maybe more, if you have a complicated situation, you could end up with a tax issue on their hands. Also, if you have a trust that you're leaving behind, so if you're doing tax planning for your spouse or trust for the benefit of your children ongoing for the rest of their lifetimes, then you probably want to avoid probate because you want to avoid those trusts from having to be created by the court and to always have to go back to the court if any change is needed. So again, it's just about ease of administration. But if you have a very simple outright to the beneficiaries, no further trust, no taxable estate, no issue finding your next of kin, probate might be totally fine in your case. But it's something to pay attention to. So when we start to talk about electronic wills and what that means and what they are, the important thing to realize is they are still wills. They're still going to need to go through probate. They can still be contested by your next of kin. They still require probate in every state of which you are which you own property. And so the only thing we're really looking at that's different here is the method of executing the will, the method of signing it, how to do it, and how to make it valid. But it is really important to understand that if your goal is to avoid the court, to avoid the process of probate, and all of those things I just discussed, then electronic wills are going to be no better for you than a will that you would sign in an attorney's office or on your own, because electronic wills still require probate. And realize, and I'm going to talk about all the different ways, all the different things that have to go into signing an electronic will, but realize that if you part of the process of signing a will right now, if you sign a will in my office, you would come to my office. I'd have two witnesses. The witnesses' signatures would get notarized saying that you were of sound mind. I will have seen you face to face. I can tell that there's nobody on the other side of the camera. I can tell there's nobody off to your right or off to your left saying anything. I have full control over what's going on because I control the room and the environment. And so, right off the bat, I'll tell you one of the biggest concerns about electronic wills could be that if you get to a point where it's going to go through probate and you do have those angry beneficiaries, you have someone who should have received because they were a distributee, but if you had no will, but now they are entitled to contest the will that disinherits them, they may have a new set of legs to stand on when it comes to challenging a will if the will was signed in this manner. So I would say that it's really important to realize that to make sure that you're not creating a bigger problem than is worth by doing an electronic will. So what is an electronic will? So first of all, Governor Hochul signed the Electronic Wills Act on December 12th of 2025. It is not in effect. So December 12th was over 6 months ago, right? But this law is not in effect. It has been signed, it's on the books, but it's not happening. E-wills will not be effective until 545 days after the law was signed. So we're talking mid 2027. So between now and that date in 2027, if you sign a will electronically, even if you follow all the things that I'm about to talk about, it will not be a valid will document. It cannot be until the effective date of the will. I will also point out that legislatively, very often a law gets signed and then there are tweaks that are made to it. They call them chapter amendments, where it might change. So the information I'm giving you today is the information available today on electronic wills, but it could be that by the time it goes into effect, about a year from now or so, it has different rules that govern it, or something slightly different, maybe another formality, etc. So this is really still a work in progress. But the reason that I thought this was important to bring to you, and the Shelter Island Public Library thought it was important to bring to you, is if you've heard about it and if it's something you're thinking about doing, it's really important to understand the requirements and to understand that you can't do it yet. Because the worst thing that happens is that somebody thinks they have a plan in place and that plan is not valid. The goal that the legislature and the governor believes is behind doing this, creating this law, was to make it more accessible to people to do estate planning documents. And that's great. Accessibility to the public is wonderful, but I just beg everybody to get the proper advice and counseling surrounding that will and the rest of the planning process. So we're going to go through the different elements of what an electronic will is. So first of all, it is an electronic document. So it has to be readable as of the time it's signed. So me getting on a video and saying, it's my wishes that everything that I have goes to the Shelter Island Public Library, that is not an electronic will. So audio or video recordings will not be satisfied. It must be a written document that is in electronic format. The original document, and I'll say original document because it's electronic and not a wet ink signature like we do now with a pen with ink in it, is the digital file itself. So it has to contain an audit, it has to contain audit trail data. That is a whole other level of software required to understand what audit trail data is, metadata tracking, to make sure that the document that was electronically signed was the same document, or being presented was the same document that that person believed they were electronically signing, and nothing was changed about it in the interim. So it's very important that you have that the attorney have the right software in order to do this. And once it's executed correctly, it has the same legal standing as a traditional will. Again, it still requires probate. It still requires this process of being validated by the court after your death. It's just something that you can sign virtually. So you can electronically sign. A lot of you have probably electronically signed documents all the time for your bank, for whatever it is. That's where you affix your signature on a document through the computer. And you have to sign it at the end of the document, same as the current status for a will. And this is interesting and different from the paper will that is signed with wet ink. or I'm sorry, not different, but an interesting thing to note is that it can be signed by a proxy in the testator's physical presence and at their direction. Now, I'll tell you, it would be very uncomfortable again to try and prove after someone's death that they didn't sign the document and they weren't in person, that they had someone else in the room with them who they told to electronically sign a document. It's just another hurdle that makes it more difficult for us to prove that this will was actually someone's wishes. And so again, if you're in one of those difficult situations, I would say you certainly would try to avoid signing electronically with someone else signing on your behalf. It just feels a little difficult, and we would have to see how the case law starts to point after this comes into effect. It requires at least two witnesses. That's the same as a regular will. Both witnesses must be domiciliaries of a U.S. state. So that means they have to be people who live in the United States, in one of the states. And it can be signed, the witnesses can sign either in the same room as the person signing the will, that we call them the testator, or electronically. And remote video conferencing is allowed. So we could use Zoom or Microsoft Teams or whatever it is to do video conferencing, even FaceTime. The witnesses have to sign the document within 30 days of the testator signing it, and they can fill out a document that says that it's a self-proving affidavit saying that the will was signed by so and so, and this is who oversaw the drafting, and we were the witnesses, and this person was of sound mind, etc. Um, then that affidavit, and we do that, by the way, with our current wills as well. We do self-proving affidavits. Then the witnesses' signatures are notarized. So if I'm signing my will, my signature doesn't get notarized, but I have two witnesses, and those witnesses are notarized on a self-proving affidavit. Now, this is really important. Within 30 days of the will being signed, it has to be electronically filed with the New York State court system. If it is not filed with the court system within 30 days, it will be an invalid will. This is a killer of it, right? You have to make sure that it's electronically filed within 30 days of its execution, or else the will not be valid. The will has to have a caution to the testator. Again, that's the person signing the will. It has to be bold. It has to be in 12-point font, and it has to be double spaced, and it has to be at the front of the will document. We see a very similar caution to the principal on the front of the New York State Power of Attorney document. So this is a similar concept and a similar practice. And basically, it's to tell someone the rules. And I'm going to read that to you just so you understand. It's not too long, but the caution to the testator. Your will is an important document. As testator, your will should reflect your final wishes. To be valid, it must be signed by you or another individual authorized by you and who is in your physical presence at the time of signing. So, just to stop for a second, that means that if I would like one of you to sign off on my behalf, I can't be on video conferencing with you and have you sign off. You need to be here with me in the room in order to do that. It must also be signed in your physical or electronic presence by at least two individuals, each of whom is a domiciliary of a state, and each of whom signs the will within a 30-day period after witnessing you sign the will or acknowledge that you signed it. Within 30 days after the electronic will is executed, it must be electronically filed with the New York State Unified Court System. You may revoke your electronic will at any time. So basically, this caution, as written, is telling the testator the overall rules that I just went through with you. Now, as for the revocation, you can revoke it in two ways. One is you can go to the court or send an authorized representative to the court to remove the will from the court's custody. And I say send, but it's it's unclear if it's a physical sent, but it's probably something that could be done electronically as well. But you can basically unfile it with the court, is what they're saying. Or you can do a subsequent instrument. So just like now, if you sign a last will and testament, and then 3 months later you sign another last will and testament, the second one revokes the prior. And that's the same thing with the electronic. So those are the two ways that you can revoke an electronic will. Now, with a paper will, one of the ways we revoke it is we rip it up, right? We ruin the physical evidence, which is our way of saying this is not my wishes anymore. But you can't obviously do that with metadata and the electronic file. So the way you do it is by removing it from the court's custody. And like I said, we have to have the self-proving affidavit signed by the witnesses, and they need to be notarized. And now that notarization of that affidavit can be done with a remote notary. So a remote notary which is electronic notarization, which can be done via remote video, as long as the notary is located in New York State during the session. So that's a separate law too, remote notarization. So we need to comply with that law as well. But again, it still requires probate, right? It still requires the court to validate the will, to appoint the executor before it can move forward. But I can see this being a very helpful process for those who, for example, are bedbound or who live in a more rural area where it's very hard to get to the lawyer's office. But I just want to caution that it is not a fix-all, and we need to be very careful that we're not creating more litigation. So if you are in a situation where you think your will is likely to be challenged by one of your distributees, by one of those next of kin, I would encourage you to seek advice of counsel before resorting to an e-will, because it might not be the best option for you moving forward. I'm going to pause right now and see if there's any questions on either the probate process as it has always been or on electronic wills. And then if there are no questions, I'll move forward to talk about trusts, which are one of the ways that we avoid probate. And as Sarah mentioned here, you can put questions right into the chat if you see that on your Zoom, if you would like to ask a question. So again, I'll just pause for a minute to see if anyone has any.
You can also do the raised hand option if typing is a little tricky for you, and we do have the built-in Q&A section done through Zoom also available.
No questions. Okay. Well, if you come up with any, feel free to put them in the chat and I will answer them. But I will move on to talk about trust now. So when we talk about avoiding probate, for all the reasons I mentioned earlier, we do that through beneficiary designations, through joint ownership of accounts, or by creating a trust and transferring assets to that trust. So if all we're looking to do is avoid probate, we do that usually through one of those three methods, maybe sometimes all three of those methods, right? And so let's say we're talking about someone's house and they want to avoid probate on their house. Well, one way that you can avoid probate on your house, which has been done for many years, is by giving a life estate deed. So you basically sign a deed that says, when I die, so and so will inherit the property, but I reserve a life estate for myself, which means I can live here for the rest of my life. I'm entitled to all assets, to use and occupancy of the property, and immediately upon my death, this is who it goes to. In a lot of cases, we caution against that because it is giving an interest presently in the property. So if I give a life estate deed to my daughter and then I change my mind later in life because I really want the house to go to both my children, I can only give it to my other child as well if my daughter gives it back to me. So it's giving a gift that cannot be refunded unless the person wants to give it back. We can't force anything back. And another reason that you have to be careful with a life estate deed is because the IRS assigns a value to your life estate. So your life estate, your interest in the property decreases over time. So while you're alive, if you sell the property, you now only own a percentage because the balance at the diminishing balance as you get older is owned by your remainder beneficiary. So you want to just be careful with a life estate deed, although in certain circumstances it's appropriate. The other type of deed that people create, and this is a very new law, and we haven't really seen a lot go on with it yet, but I'm sure that there will be plenty to learn about it over time, is something called a transfer on death deed. A transfer on death deed is a deed that names a beneficiary, and then the deed gets filed with the court. And if you change who the beneficiary is going to be, you just go and file a new transfer on death deed and change who the beneficiary is going to be. There's a lot of reasons that a lot of attorneys are concerned about that. First and foremost being there's nothing to notify the individual who will receive it on death that they are the beneficiary. And so depending on again, the facts and circumstances, this may or may not be a good idea. But I find that a lot of attorneys shy away from them because we are all worried about the title companies and how they're going to be viewing these deeds into the future. And so we want to wait a little and see what happens. And then the last thing that people do on a house to avoid probate is create a trust and then sign a deed transferring ownership of the house to the trust. And depending on the type of trust and depending on the goals that you have for yourself and for those you're leaving assets behind to, the trust can be drafted to give you full control. You know, if all we're doing is avoiding probate, well, then we can create a revocable trust. We sign a deed making your trust the owner of the property. You're the trustee. You manage, you control. You can use every dime in it if you want. You could sell the house and go gamble it in Vegas, or you can leave it as a house and you manage it and maintain it and pay the taxes, etc. And then it passes on without court intervention at your death. If you're looking to get Medicaid protection, so you don't want it that your house can be counted as an asset should you need nursing home care or home care services, well, in that case, we could put your house into an irrevocable trust. The irrevocable Medicaid Asset Protection Trust can still give you all the tax benefits, real estate taxes of it being your primary residence, but also will avoid probate at your death and will not be countable should you or your spouse need nursing home or home care benefits. Or there's various other types of irrevocable trusts that can be helpful for people who have very large estates, a single person over 7.35 million, or a couple, that's over 14.5 million. Then we may create a different type of irrevocable trust to protect that asset from being taxed at your death. But it's really going to depend again on your facts and your circumstances. But those are the different types of deeds that are available. Now, a revocable trust is just as I said, it's revocable. You can change it, you control it, you can do anything you want. You could use every dime in it, you could save every dime in it, and everything in between. It carries your own social security number. You don't file additional taxes for it. It gets filed under your tax returns, and it is merely to avoid probate. If you do an irrevocable trust, it depends on the type of trust. Most often, for the Medicaid irrevocable trust, the assets in the trust are part of your taxable estate when you die. They receive a step up in cost basis at your date of death, but you're restricted on the use of principal. But if income is generated by assets in the trust during your lifetime, then that income will just be basically be passed through and reported on your personal tax return. So it can be a really powerful tool to create a trust and move assets, especially a home, into the trust to avoid probate and potentially plan for Medicaid. Now, I want to take a second and briefly discuss capital gains because I mentioned that you still receive all the capital gains benefits in the trust. So let's say you purchased your home for $100,000 and now it's worth $1 million. That's $900,000 of gain. If it's your primary residence, you get a $250,000 exclusion from gain. So you bought it at 100,000, that's your basis. You get a 250 exclusion for it being your primary, 500 if you're a couple. So let's say it's a couple. So now your basis is the 100 that you purchased it at plus the 500, so you're at 600. Then maybe you put in a new boiler and a roof and now you're at 700. Well, then you would, if you sold it during your lifetime, pay a capital gains tax on the difference between the $700,000 basis that you now have and the $1 million sale price. And you'd probably pay in New York about $100,000 in tax. The more improvements you've done, the more you can get off of that. Now, if upon your death you still own the property or one of these trusts owns the property, you'll still get a step up in cost basis at your date of death. So if you die and it's worth $1 million up here, well, then your family inherits it. They sell it for $1 million. There's no tax because it got stepped up to your date of death, and now that wipes out any capital gain. So a lot of people like to hold on to properties, especially properties on the East End that have gone up in value quite a bit because they want to avoid the capital gains taxation of that asset upon sale. And so they want to hold on to it to pass it on at the higher cost basis. Then obviously people just want to pass things on where there aren't huge taxes owed because you don't want people to be in a situation where they can't keep the property because of taxes. So people like to be very careful about how property passes and making sure their intentions are followed. And then the trust can say whatever you choose. It could say, upon my death, my trustee should sell the trust and split up the money. Or it could say, I specifically give my house to this person or these people. Or I give a right of first refusal, meaning the property can be bought by this individual before it's put on the open market. But those are all options that you can put within your trust documents to make sure your wishes are followed. So to recap what we talked about today, we talked about good old-fashioned probate, right? The process of putting your will through probate with the court so that your legal next of kin, otherwise called your distributees, are able to come in and contest the terms of your will if they thought that it wasn't your signature or that it was signed under fraud or duress, or honestly, if they were just trying to be difficult to get paid to go away, right? So that was the first thing that we discussed. Then we talked about the old-fashioned paper wills, which we still sign across the board, and we will continue to sign for a very long time in our office, where we take paper to pen and we sign a will document. And then we talked about electronic wills, which will go into effect probably mid 2027. So it's 545 days after the date it was signed, and it was signed December 12th of 2025. So the electronic wills are means by which an electronic document can be electronically signed by you or a representative and electronically witnessed by two individuals whose signatures are then notarized in order to create a valid last will and testament that can be filed with the court and must be filed with the court within 30 days of the electronic signature. And there's a lot of formalities and requirements to how this should be done, and that's all spelled out in the law. And then we talked about the fact that even though it's an electronic will and even though it's new and shiny, it still will require probate of that will in court. And so for all the reasons you might want to avoid probate in the past, you still may want to avoid probate. and even more so potentially because of the fact that the document that is being admitted to probate is an electronic document. And we, depending on the circumstances by which someone signed it, we want to make sure that nobody can claim that there was a lack of capacity or undue influence that forced you to sign the document. And then we talked about probate avoidance, which we do through beneficiary designations, joint ownership, or trusts. And we talked about revocable versus irrevocable trusts, avoiding probate with those, and then also potential tax benefits as well as Medicaid asset protection. So that's all I have for you today. I thank you for logging in. I will hold to see if there are any questions. And again, you can write them into the chat or raise your hand if there's any questions. We are recording this, and it will live on the Shelter Island Public Library website, and we'll also put it up on our website. If you have any other information, our website, burnerlaw.com, is a great resource. All the articles on there are written by attorneys of our firm, so they are not, SEO copyright written. They are ours, and they have a lot of great information that just helps you start to understand the process of estate planning and what might go into it, so you can make sure that you have the best plan possible to protect you and your loved ones, given your particular set of circumstances. So thank you again to the Shelter Island Public Library, and I'm Britt Burner. It was a pleasure being here with you today.
Thank you so much, Britt. We appreciate it. And I guess everyone have a fabulous afternoon.
Sounds good. Thank you, Sarah.
Awesome. All right.
All
Thanks,
right.
guys.
Bye.